Time is limited, but your success doesn't have to be. At LawPay, we are committed to helping you succeed while making the most of your valuable time. Try our simple, secure online payment solution today, and you'll pay no monthly fee for a whole year. Learn more at lawpay.com/dcbar.
Hi, everyone. I'm Kirk Schroeder. I'm an entertainment attorney with the law firm of Schroeder Brooks, and I am here for Brief Encounters. And today we're going to talk with a special guest about royalty audits for those attorneys that have license agreements, any type of entertainment, software, other things that require audits with respect to royalties. And I'm pleased to bring together in this podcast a friend and colleague, and he is Elon Heimoff, partner in the Hollywood-based public accounting firm of GHJ Advisors. Elon, welcome to Brief Encounters, and thanks for joining us today.
Thank you for the opportunity. I appreciate it, Kirk.
Elon, I know we could spend a whole day talking about royalty audits and what you do, but in our brief 30 minutes or so, we just want to have an overview of royalty audits and how they work. Let me just start off with just asking what's involved in a royalty audit. I haven't really qualified your background, but you've done many of them. Your firm specializes in them. For our audience, Elon and his firm is very well experienced with major studios and other major payors of royalties in this regard. So having just quickly qualified you, can you just tell our audience what's involved in a royalty audit in the big picture, and we'll just start going from there.
Yeah, let me give you a little bit of background about our area of specialty. So I am one of about 20 of us within the group called Profit Participation Services Group at Greenhouse and Jenks here in Los Angeles. Because we are in Los Angeles, our focus is Hollywood, as you mentioned, but we do perform other types of royalty audits, and they go far and beyond the film industry. We get involved in video games, sometimes with music publishing, merchandising, even various other types of consumer products, just depending on the client and what the client needs may be. So there's a variety of industries that we get involved in, but the primary focus is film and television for the most part, just because of the history of the firm and how far back we go. So that will be my reference point. So when I talk about the audit process, I may make mention of the film and television area.
Well, but when you talk about like video and others, they're just different accounting formulas and net profit definitions that you have to go through. Is that correct?
Yeah, they all have one common element, which is the agreement. So there's going to be an agreement that drives the relationship between the licensor and the licensee. And we're auditing effectively the licensee on behalf of the licensor. So there is going to be somebody that owns the rights. It could be an inventor, it could be the creator, could be a company that has a series of characters that they own, or there could be a company that has a script or anything that is essentially, in their portfolio of assets that they own. Somebody else is taking those assets and exploiting them by manufacturing units or widgets or exploiting it in creating a video game. I think you mentioned that could be another example. And our responsibility is to exercise the right of the licensor to audit the books and records of the licensee in connection with their exploitation of those assets. And a simple example could be someone who is a manufacturer of apparel goods, but wants to use, say, a known character from, say, a series of animation. And they'll pay, the licensor, could be a studio, could be the creator, a royalty per unit. For the agreement. Our responsibility, again, as auditors, is to go in to the licensee's offices, virtually or in person, depending, and review the accounting that's associated with those royalties that are paid to the licensor. So essentially what this is effectively our role is to validate that the licensee is reporting the sharing of the net profits of the success of the exploitation of the asset in the marketplace back with the licensor.
And we'll talk about what goes into the audit provisions, but essentially, once that net profit definition or that royalty definition in the agreement's defined, you're following that. And of course, you're familiar with industry customs based on your firm's experience. Let me ask, just in general, what's involved in the audit? The minute that you get the call to go out and audit, how long does it take? What does it involve? Is it an overnight process? Does it take years? I think I know the answer to some of these questions, but just for our audience, What's involved? It's not as easy as just, oh, you're going to fly out in 21 days and check everything and it's all done, is it?
No, no, well, it depends. I mean, I think that an audit could last probably as long from the point of inception to the point of conclusion, and I'll explain what those mean. Anywhere from probably 2 months in some cases to, in extreme examples, to as long as 2 to 2.5 years.
Yeah.
It's a fairly wide timeline. I'll give you examples of those two extremes. On the one side of that spectrum, if we have a fairly defined and fairly limited scope of our audit, whereby we travel, say, to a location, and we know we only have a limited amount of time to be able to review the records on site, we will effectively plan in advance, but then go in and then get out and essentially issue the report. But again, the condition to this being only 2 months long is that it's a fairly narrow scope and it's a fairly simple engagement. On the other hand, when we do a worldwide distribution audit where we have to travel to, say, 5 to 6 different locations around the world, by the way, whether in person or virtually, it doesn't make a difference. But where we, in that particular example, we've looked at thousands and thousands of transactions, probably as many as 10,000 transactions. That's obviously going to take about maybe 2.5 years long. The way this works in every agreement, in some agreements, it's more defined and more detailed than others, but in general, we would be confirming the scope, first of all, with our clients, which again will be the licensor. And once the scope of the audit is confirmed with our client, we then, with permission of the client who notifies the licensee of the audit, we then begin communications with the licensee with pre-planning, making sure that there is an understanding of what and how information is going to be communicated back and forth. In some instances, we have to sign a non-disclosure agreement. There's a variety of pre-planning that we have to get through. But once all of that is out of the way, we submit various requests for documents, and then we go back and forth throughout, let's say, call it field work, which could be, again, virtually or in person. And at the end, there's typically an exit meeting where we go through whatever is remaining in terms of open items. Some of the key issues that we come across with the client's permission, of course, we then bring it up during the exit meeting and vet any information we haven't seen or haven't considered. It all follows with an audit report, which is submitted to the client, who will then in turn submit that to the licensee. There will be a settlement, which we will be a part of, depending on the client, and then hopefully a settlement and conclusion of the audit and the various claims included in the audit report.
I think this has been my experience, but I don't know, you have a broader experience. But I mean, most of the major studios, if you negotiate certain net profit definitions or different definitions with respect to royalties, they don't necessarily change their accounting systems to adapt to that. They just kind of have a straight accounting system, and you just need to audit them as a practice if there's money there. Is that generally true?
So we, particularly at the studios where we audit on a regular basis, we have to understand those accounting systems and processes in every single one of these studios because they are not the same. To be as efficient as possible, we specialize, again, within our film and television business, we specialize on a studio by studio basis. So I myself, for example, have an understanding of some, but not all the studios. And that's important because they would expect us as auditors to understand that process and use the lingo they're used to in terms of what records we need, what reports we need. And I think the more knowledgeable you are of the process, probably the more efficient you're going to be. And so they're not going to change their system, their process. You have to adapt and you have to work your way through the maze of their existing systems and processes.
But I guess my point being that you may have in an agreement some definition that's not necessarily standard or altered, and their computer does not account for that. So that you then have, as a client, you have to make a decision as to every 5 years or whatever the life, if it's worth an audit or not. Can you talk about what are the factors in determining whether or not an audit is worth it or not for a client?
There are a variety of ways to consider, or factors to consider when you think of auditing or not auditing. I think, first of all, is the agreement typically would specify once you get a statement, you may have a period of time to challenge that statement.
Is that like typically 2 years? Is that like a customary?
24 months is the typical time frame, but in some instances I see 12 months, 18 months, 36 months, 48 months. It just just depends on the deal and depends on the leverage.
But certainly no less than a year. You may not realize something's happened in that point in time, right? So as a practitioner, you want that period to, I would think, at least to be 2 years, if not longer.
Yeah, the longer the better because we need time. Sometimes doesn't tell the whole story. Looking at the patterns, I guess, from statement to statement does help identify potential areas of risk. So the longer we have, the better it is. But I think we need to recognize that timing within the agreement does play a big role. When you know that a particular statement, which typically will be the first or second or maybe even the third statement, is soon to expire, meaning you need to make a decision within a period of time, that's the time for you to get us involved. And what we would do is we would review the statement based on our past experience, identify anomalies, identify high level unusual transactions. We have a conversation with the practitioner, the attorney, sometimes the company itself about areas of concern they may have. But we do work together with our client to identify areas of risk. And there's a variety of areas of risk that can give some examples. Sometimes you've got a significant adjustment that you see on a statement that you did not expect. The agreement itself, the actual agreement itself is not signed, or there may have been right at the beginning of the relationship some agreement to disagree in terms of what the terms are. So agreements may not be signed. There could be multiple versions of the agreement. The agreement itself may be so complex that the two parties may or may not necessarily understand the underlying deal. And maybe it's vague enough that one could argue that it should be interpreted one way and another could be interpreting it a different way. There could be issues, by the way, with the licensee that our clients may be aware of that could raise the red flag. For example, they may be just about to get acquired. There's a high turnover of management. There are many, many errors that have been corrected where they provide us multiple versions of the statement. There could be different things that could raise the red flag that together, working with our client, again, within the time frame that we have, we work together to identify if it's worthwhile pursuing the audit or not.
Okay, let's just talk about different industries. I mean, I guess going back to like the Buckwald case and other things, it used to be that the studios had these ridiculous net profit definitions that you could run a train through them for expenses. Television, I know we've done deals where you're trying to figure out if you're getting the A net profit definition or the B version or the C version. And I guess Hollywood in the film and TV area have not changed much. But when you go look like the video game industry, a lot of that is pretty streamlined in their accounting and net profits. And I don't know about merchandise. I'm just wondering in the various different industries, from your experience with respect to custom, what industries still either maintain complexity, which industries tend to be more straightforward in their definitions that make things easier for you as an auditor?
Yeah, so I think starting with the film and television industry, I would say that it is fairly complex and it's actually getting more and more complicated because of the various significant changes that we're seeing right now with the transformation of the streaming services impacting the whole waterfall of a television series as well as film. So I think this is an area that is actually going to get more and more complicated and difficult. And so consistency will not.
What is it about a streaming service that's now affecting a definition? Is it a reduced rate because it's streaming? Is it, like in the book industry, you have to take 80%, or they want you to take 80% for Canada, for example, but it's Canada. And how difficult is it to audit something in Canada? Is that what you're finding in streaming, or is there some other calculation in how streaming is dealt with?
Yeah, and I'll give you a couple of examples as to how the streaming business is impacting the deal making. So we have in our audits, the deals that go back, say, to the even I would say prior to 2005, earlier in the 2000s, and even further back than that, the definitions did not include, or there may have been some unclear definitions as to how to account for revenue coming in from streaming services. Is it part of the traditional home video royalty reporting? Is it perhaps classified as television? It's just it's not clear. And so when you look at reporting today, based on definitions that go back almost 20 years, there's a question as to how to report it. That's one issue. The other issue, particularly during COVID, say a motion picture that traditionally would go through the normal distribution pattern where it goes to the theater and then there's a black period and then it goes into paid television and so on and so forth. What happened was around the time when COVID hit, a lot of studios experimented and tried different ways to distribute film where they will have day and date, or in other words, they'll have it made available for streaming and the theaters at the same time. They may not even have it available for theater distribution and go straight to streaming. And what that does, it has a ripple effect on the waterfall and the ultimate distribution of the motion picture, the film itself, because the various deals downstream depend on the success of the film in the theaters. And so if there's no theatrical distribution whatsoever, how do you value say, the paid television valuation of that motion picture when it's time to distribute it for paid television?
Yeah, so essentially there's still a struggle in how streaming is classified based on old definitions and emerging definition. How about like video? My experience is that video is a little more straightforward in terms of how the gaming industry, how they define net profits. The accounting is much easier than it is in the TV or film area. And I don't know if that's your experience or if I'm just dealing with the wrong folks.
I think depending on the type of reporting, you're right that it's relatively straightforward. If you are the developer of the game and you were able to negotiate a net profit definition whereby you actually earn the benefit of the ultimate net profits of the publisher, the actual entity that works with the consumer, I'd say that that is fairly complicated, particularly because we're moving into more of a subscription-based video game environment. And the key question is, all right, if you're getting the benefit of the net profits, what portion of the subscription is allocable to your game? And I think there's a lot of complexities around.
With packaging and things of that sort.
Yes.
Got it.
So there's some complexity, but you're right. Generally, it's going to be relatively straightforward. By the way, no different than consumer product. That is generally relatively simple. It's all about in consumer products like video games. You would think it's just the number of units that are being sold. I think video games are getting more complicated because of the subscription model, but with merchandising or consumer product, that is relatively straightforward. It's okay, how many units did I make and how many units did I sell? And all you really have to do from an auditor perspective is going back and verifying those number of units in fact.
Yeah. Just real briefly, and then I want to move on to another topic here. The metaverse. Have you had to do any audits in relation to income streams in the metaverse? And is that going to present its own set of issues?
Not yet, but we know that this is potentially coming. And again, with the limited information that I have and knowledge that I have, there is hopefully an audit trail of individuals getting assets, I guess, virtual assets being acquired and ultimately continuing to sell those off to the next party. And there's apparently a royalty stream that is required to be paid back to the originator or I guess, the licensor. But at the moment, it's in more theory than practice for us.
Mm-hmm. How much of your practice involves investors and investors that have a royalty stream or in the waterfall somewhere, and they want to confirm whether or not they're actually getting recoupment or the ROI that's been promised in an investment agreement or as part of any type of equity in a project?
More so than ever before. So yeah, Kirk, we have more and more investors coming in, particularly in the film and television space, asking us to validate that their deals, were followed. And I think a lot of it has to do with probably having to report back. Many of these organizations, which could be a private equity firm, it could be an agency that will work on behalf of various other investors, more so from a compliance standpoint and due diligence standpoint to get us involved. And so, but I would say to you that I think that more and more of them are coming to us. Yes.
Yeah, that's been my experience as well, especially when you have a filmmaker or someone that is saying this is a mezzanine financing, which I'm not going to get in, but when you really look at the details, it's really an investment in a waterfall, and you're trying to understand what the royalty pools are, what union requirements are, things of that sort. Sort of in our final 10 minutes here, what are good drafting techniques for attorneys? What sort of things would be important for an attorney to know with respect to drafting a audit provision?
I mean, a couple of things I can think of. I think it's important for us, and I think we've said that already, to give the client, the licensor, the party that, again, has the right to audit, more time to consider auditing. I think that the first statement is very difficult to assess. I think from inception, hopefully we get to see a few statements and see a pattern of transactions. So again, more time. If you can, more than 2 years is, I think, will be a success.
And just for our audience, that's usually a provision that says if you do not object to a statement rendered within a year or 2 years, then it's considered accepted. Some language to that effect.
Yeah, that's really, in other words, it's, are you going to be able to contest the transactions within the statement? And they usually give you a period of time. So yes, I would say more than 2 years. The other, if you can negotiate that within the provision, is if we find as auditors more than a X dollar amount or more than the value of our claims that are accepted by the other side, more than 5% of the net reporting, or 10%, in some cases, that the licensee would pay or reimburse the licensor for the audit fees. I think that's one of the things that I would recommend. If you can do that, if you can get the other side to accept audit reimbursement within the audit provision.
5% is pretty customary, isn't it? I mean, my experience is at 5. I've seen it at 10, but
If you can get five will be the best we probably can get, but I would say even if you get 10%, it's still, I think, a success because less and less companies are willing to accept an audit reimbursement provision.
let me ask, sometimes I will ask to make copies because if you don't specify the ability to maintain copies, for the audit purpose, they won't let you out the door with documents. Is that over lawyering on my part or is that a concern?
No, I think that I've seen a couple of instances where clients are able to get copies of documents in connection with claims, not just copies of everything, but just copies in connection with claims that we include in our report because we do need to have the evidence to support the claim. In other instances, we're able to get at least some documents provided to us electronically. So I would say, Kirk, it's not so much, and I say copies, in order for us to be efficient in doing the work today, more so than ever before, we do virtual audits. And in order for us to be able to perform our audit, we need to get copies of transactional detail for us to make sample selections from. So I think that when I think of what I absolutely need in order to make the audit efficient as possible is subject to an NDA, that we will be able to have access to certain documents electronically in order for us to be able to perform the audit. Now, they may not necessarily be willing to allow either the attorney that represents the client or the client have access to some documents, but at least us as auditors, we should be able to have access to information virtually as much as possible.
You jump into another quick point. Sometimes there are scenarios where they will not let the client have the document, but they will you. Tell us about that practice and what should attorneys do in that scenario?
Great question. It depends on the situation and depends on the NDA that we had to sign in order for us to be able to perform the audit. So typically, where we do our best, in instances where we are limited to what we can share with our client, we do our best to be as descriptive as we possibly can in the reports. So that way you have all the information that you need as an attorney to be able to negotiate ultimately the claim with the other side. So the way even though we can't give you the documents, perhaps based on our limitations or restrictions from the NDA, we need to make sure that you understand the issue. And if it's not enough, I think that's really where, on an exception basis, we will then recommend that you reach out to the licensee and try and negotiate getting information. We have other instances, which I think that in anticipation of this issue, we would have the NDA that we as auditor have with the licensee also signed by our client and or the attorney that represents the client. So that way, all of us have access to documents from the beginning of time. So I think that there's a variety of ways to deal with this issue. If it's only the auditor having access to it, we try and again make the claim be as descriptive as possible in the report. But we also try our best to get you to sign the NDA right at the beginning of the audit, so all of us have access to the same records.
Okay, one quick question, and then we're going to be near a close here. How much advance time for notice? Is it like 21 days? Is it 30 days? Is it 3 months? Or does that matter? I mean, obviously, the sooner you can give notice to begin the audit process, but is there any custom that you see with respect to that?
In the film and television industry, check with us first. Because in some instances, you want to notify as soon as you possibly can. In other instances, we actually suggest you wait as long as you possibly can. So this depends on the studio. It's a long story, but we have different queues at different studios. In one instances, we have several years of having to wait. In other instances, it could be within a month. So I would say in film and television, please check with us. But in general, I would say that I think customary 30-day notice is reasonable.
Okay, in our just last a minute or two, what advice do you have for our audience that are dealing with these sort of provisions and or anything else, just as a closing?
The best advice I can give everyone is keep us in mind during the negotiation process and feel free to reach out to us. That's one thing. The second thing is the audits are customary across multiple different industries. Pursuing an audit does not mean you don't trust the other side. Pursuing an audit does not mean that it could harm the relationship with the other side. It is your right, the client's right to pursue an audit, and it is customary in various different industries to perform an audit. Ultimately, the kinds of issues that we find are more interpretive in nature. So it's the other side perhaps not following the underlying deal, and pursuing an audit will reveal that, will identify that. And I think that considering an audit is your right and isn't in any way, shape, or form intended to show a lack of trust in the other side.
Okay, great. Elon, thanks for joining me today, especially all the way from Hollywood. For our audience, we've been talking with Elon Heimoff, who's with the Hollywood-based public accounting firm of GHJ Advisors about royalty audits, and this has been a great discussion, so thank you so much. This is Kirk Schroeder with the law firm of Schroeder Brooks, and thanking the DC Bar, and you've been listening to Brief Encounters, and join us again next time.
This episode of Brief Encounters was brought to you in part by our sponsor, LawPay. Schedule a demo at lawpay.com/DCBar to see why LawPay is trusted by 50,000 law firms.